Hello, friends. It's been a minute. I've missed you. I've also missed having a camera, but apparently that's sorted now. I've seen quite a bit of buzzing and received more than a handful of phone calls about the present situation with forced reset triggers. We're aware of ATF conducting some stings on auction websites and harvesting some customer information, but we're not completely sure what else is in the cards right now. Recently, though, I've seen some commentators talking about how Big Daddy Unlimited said the FRT-15 is a machine gun and that this caused the court to ask the ATF to step in. So, unlike some channels that would rather be quick to the punch than accurate, I decided to actually read the filings. Let's take a look. All of this relates to the patent battle between little-known companies Common Breed Triggers and Little Mommy Limited. We've done a video on this channel a while back discussing the patents at issue, so if you're a nerd like me, you should probably check that one out. To put a quick button on it, basically Common Breed Triggers came out with their FRT-15. It's a trigger that forces itself to reset with every shot. Later on, Little Mommy came out with the whatever they called it that week, which also slap your finger forward every shot. This led Common Breed to assert that Little Mommy copied its homework while the homework was still subject to special governmental thought monopolies called patents. As for the instant kerfuffle, defendants, led by Little Mommy, filed a claim construction brief. The purpose of a claim construction brief is to lay out to the court your argument for why a patent should be read a certain way. These are one stage of the protracted, murderously boring, lobster-clawed battles in the circus scam that is intellectual property. To aggressively simplify this stage, the purpose here is to say something like, hey government, you gave them a monopoly on a ball tied to a stick with a string, but that doesn't include balls tied with chains or gourds tied to the stick with a string. You get the idea. Well, in that brief, in the opening parts, the Little Mommy lawyer sets out some background information. In this paragraph, he explains his theory that a previous patent preempts the FRT patent because they operate on the same basic mechanical principle. This previous patent was actually a binary trigger. A binary trigger that does involve a similar locking bar to the FRT-15. While that previous patent was not a forced reset trigger per se, the argument is that the prior invention makes the FRT obvious, not novel, or in some other way not eligible for patent protection. At the end of this paragraph, he throws the jab that the only real distinction between the FRT and the FOSTEC, the previous trigger, is plaintiff's willingness to operate outside the law, not any technical improvement. So from this, we saw people freaking out, coming up with theories that Big Daddy has now flipped the bit and is working with the ATF and is going to do the thing or whatever. And you know, I don't think I agree with just about any of these reactions. Some people, like Reno May, who I love by the way, were able to reel it back a little bit, but he said some really nonsense things like this.
Maybe the lawyer was dumb. Maybe the lawyer understood what he was saying. Maybe the McKnights saw it, and maybe everybody involved in this is just a silly goose. I don't really think that's the case. These people are way too successful to be considered dumb. I don't think I would ever say that the McKnights and Big Daddy Unlimited and lawyers, real lawyers, are dumb. I don't think they're dumb. Okay.
Now this is clearly and demonstrably false. Lawyers are not smart or good. In fact, we are bad and dumb. I know there was another filing, and we'll get to that in a minute, one that was actually brought by the court. But I just want to call y'all's attention to a couple things in this initial brief that so many people are talking about. For one, nowhere in the actual argument section of this brief is it asserted that either trigger is a machine gun. Two, take a look at the signature line. That's right, this is an intellectual property lawyer at an intellectual property firm. I don't think he's making grand strategy at the ATF. I'm also not sure he's even really a gun guy. So what is this sentence then? Well, as a practitioner, I've seen stuff like this quite a bit. Lawyers will kind of want to stick it to the other side and put little jabs in the background and other non-argument sections of their briefs. Of course, if you are as boring as an IP lawyer has to be in order to survive, your comedy will be kind of crummy and your timing bad. You might also notice that nowhere else in the brief is this even mentioned. That's because, unlike what some people would want you to believe, this is just a claims construction brief. They are not taking an actual position on the status of these triggers, aside from their patentability. So now let's talk to that other document, the courts inviting the government to participate in the case. People are saying that as a direct result of this claims construction brief, somehow the court asked the ATF to step in and determine whether or not the FRT is a machine gun or something. Well, this sounds absurd because it is absurd. It's also not really true. You can see from this order inviting the participation of GOJ, it clearly states, the plaintiffs and defendants assert that such triggers are not machine guns. No party in these cases has asserted or can be expected to assert that the triggers are illegal. Then we get to the point of the matter. And thus no party has briefed or can be expected to brief questions such as whether a party can recover for patent infringement based on the sale of an illegal product. It goes on to note that there is a dearth of controlling authority and case law on the issue. Basically, in situations like this, it is unclear whether or not the patent can be enforced. This is contrary to the claims that this one-liner was some kind of grand strategy for Little Mommy Limited to parachute out of the case and avoid liability. What the court is actually doing is intentionally inviting the government to express its views as amicus curiae, which is Latin for friend of the court, on questions that implicate their responsibilities. Now, are we going to like what the government has to say here? Probably not. It's probably going to be a bunch of crap. But I just wanted to make clear, in reality, this is the court inviting the government to opine so that it can kind of wade out this interesting and unexplored area of the law. Do we know that this is how they're going to rule on it? No. All we know is that the court has identified a potential problem and that neither party is going to brief it because neither party is currently claiming that either trigger is a machine gun. So that's how it is, at least for right now. That's it for today, guys. As always, I super appreciate y'all watching and subscribing. If you want to support me more than that, I have a Patreon, a Subscribestar, and a Utreon where I've got neat benefits for you. This kind of support will help me make more content more regularly, which I really want to do. There's also a link to certain merchandise, including a Magic ATF ball, a favorite, and other affiliate links in the description below. Please click on them. It helps me. And anyway, y'all take care.